Right. Good afternoon. I hope everyone can hear me. I think we'll make a start now because we've got quite a lot of people who've joined. I believe there are some more who are going to be joining us, and it's great that so many people have expressed an interest in the session this afternoon. I'm here with my colleagues, Fiona Murphy and Freddy Powell of the Actions Against the Police team. Fiona literally needs no introduction whatsoever, having been at the heart of claims against the police for many decades now. Freddy is a newer and very welcome recruit to the Actions Against the Police team. His talents are as broad as his areas of specialism, and he's doing a lot of work in actions against the police, inquests, clin neg, and employment litigation. As we all know, deciding who to sue can be a really important, really difficult, sometimes anxious decision at the start of litigation, and a decision upon which so much rests. Our role today is to help you navigate those tricky decisions, and we are going to be focusing on recent case law. Our wonderful clerk, Melvin Warner, is going to help with the slides. So Melvin, could we move through to the third slide, please? That's very helpful, thank you. So that is setting out what we're going to cover. Firstly, I will talk about the principles emerging from the two recent Supreme Court cases concerning vicarious liability, the Barclays Bank case and the Morrisons supermarket case. In both cases, judgment was handed down on the 1st of April of this year, and I'll leave you to judge whether that is an appropriate date in the circumstances. Freddy will then talk about the application of the principles emerging from those cases in a policing and detention context using particular examples. And then Fiona will discuss developments in non-delegable duties since the seminal Supreme Court case of Woodland a few years ago. We are each going to speak for no more than 20 minutes, and that should allow plenty of time for questions. Thereafter, we've scheduled about 25 minutes for questions, and we'll really appreciate your contributions, comments, discussions at that time. You can, of course, convey your questions to us at any time before then as they occur to you. Please use the Q&A function, which you will find at the bottom of the screen. That means that only us, the presenters, will see your questions. I will review the questions and allocate them accordingly, of course, making sure that any difficult questions go to a presenter whose Christian name begins with F. And so without further ado, we will commence with the first presentation, that's to say myself, talking about the elements, talking about the principles emerging from the two Supreme Court cases. So if we could move forward 2 slides, please, Mel. So first of all, just by way of a recap, a reminder of the two elements, the two tests that need to be satisfied in order to establish vicarious liability. Firstly, that the tortfeasor and the defendant are either in a conventional employer-employee relationship, or else they are in what has been termed a relationship sufficiently akin to employment to make it fair and just to impose liability. As a shorthand for the purposes of this talk, I've called that the relationship element. So a relationship sufficiently akin to employment. If you overcome that hurdle, then secondly, it's necessary to show there is a sufficient connection between that relationship, the qualifying relationship, and the tortfeasor's wrongdoing. And for the purposes of this talk, I've called that the connection element. So if we could have the next slide, please, Mel. And here I've just introduced the two decisions from the Supreme Court. The first case, Barclays Bank, was concerned with the relationship element, as we will come on to see, and the Morrisons supermarket case with the connection element. I think it's fair to say that prior to these cases, there was a strong trend towards an expansive approach to vicarious liability. And indeed, in both these cases, the claimants succeeded before the Court of Appeal. However, in both cases, the Supreme Court reversed those decisions, finding in the defendant's favour that there wasn't vicarious liability. Now, when we look at the facts, we may understand in legal terms, if not in human terms, but in legal terms, why the decisions were made on the particular facts. But the real question is, to what extent does this signal a reversal of the trend towards an increasing breadth of circumstances in which vicarious liability will be found? So if we could come on to the next slide, please, Mel. And first of all, and Freddy's going to talk about this rather more, but just to reflect for a moment, well, why do we care about the relationship element? So far as police officers are concerned, there's a statutory deemed vicarious liability relationship by virtue of Section 88 of the Police Act. And obviously, if we were, for example, dealing with someone employed by a police authority, they would have a conventional employment relationship for the purposes of satisfying this first limb of the test. However, there will be circumstances, and I've just given a few examples to have in your mind while we're looking at the principles, where you may have to consider in some detail whether the relationship element of the test is satisfied. So, for example, where your client is assaulted by another detainee, or by a member of the public involved in some way at police's request in assisting them. It may be that your client is injured by the negligence of, for example, an FME in police custody, or healthcare services in the prison context or an immigration detention context. So those are all instances, as Freddy will talk about, where it will be necessary to consider if the relationship element of the test is met. Next slide, please. So we need to know what, indeed, Barclays Bank decided. Firstly, the basic test, which I've already mentioned, namely that the relationship is sufficiently, it's satisfied where the relationship is sufficiently akin to employment to make it fair and just to impose liability on the defendant. So far, that's not new. That was already the test, but it's how that question is answered that was significant in the Supreme Court's decision. It was a joint reasoning given by Lady Howe. And she stressed that in order to answer that question, it was necessary to focus on the detailed features of the particular relationship between defendant and tortfeasor. And she emphasised that that was the crux of the test. We'll see how that plays out in a minute on a later slide. She also emphasised that the conventional distinction between someone being an employee and someone being an independent contractor, that's to say in business in their own right, remains good law, so that the former can give rise to vicarious liability on the part of the employer, the latter will not. Next slide, please. So why, or how is that different to what had gone before? Well, this is the key difference, that, as you may recall, previously, Lord Phillips, in a case that is normally referred to as the Christian Brothers case, had identified 5 features. I've set them out in the bullet points on the screen, so I'm not going to read them all out. But cases since the Christian Brother decision had used those 5 features as if they were the test for seeing if this relationship akin to employment existed. Lady Hale said, no, that's wrong. What Lord Phillips was doing there in the Christian Brothers case was explaining the policy behind why vicarious liability is imposed, not setting out the criteria that needs to be met in a particular case. And really the concerns underlying it, and we'll see that when we look at the facts of this case, is that some of these features are pretty broad and direct attention to a general sense of where in justice the liability should fall and not fall. Particularly, perhaps the first factor is the employer more likely to have the means to compensate the victim. And the fourth factor, the employer created the risk of the torts commission. I think in light of the facts and the decisions below in Barclays, the Supreme Court were worried that this sort of broad brush approach could lead to judges going off in all directions and finding vicarious liability proven in circumstances where conventionally that would not have been the case. Next slide, please. Said Lady Hale, that where it was clear that the tortfeasor was carrying on business in his own right, so an independent contractor, you don't need to look at those 5 factors at all. And she said, perhaps slightly grudgingly, well, they might or they may still be helpful in doubtful cases. She acknowledged that the 5 factors approach had been employed indeed by the Supreme Court itself in 2 fairly recent cases. The Coxon Ministry of Justice case, which was about the catering manager, you may recall, negligently injured by a prisoner working in the kitchen who dropped a bag of rice, and also in the Arms and Nottinghamshire County Council case relating to whether the council was liability for foster parents' abuse of a child placed with them. Lady Hale acknowledged that the 5 factors approach had been used in those 2 cases, but said that really the heart of it was the finding in both those cases that the individual in question was not in business in his or her own account. So the prisoner wasn't, and nor were the foster parents. Next slide, please. So I've told you it's necessary, because Lady Hale says it's necessary to look at the detailed factors of the particular relationship. So what sort of factors would you be looking at? These bullet points are simply my suggestions, but drawn from the discussion of the cases in Barclays Bank. And obviously some of them overlap with Lord Phillips's policy factors in any event, as you may notice. But these are the sort of features that to focus on if you want to argue that it is an akin to employment relationship. I won't read them out, but you can see them there on the screen. Moving on to the next slide, please, Melvin. We can see how this different approach played out in the facts of Barclays Bank. The claimants had applied many years ago when this all happened for jobs with the defendant bank, and they were required to undergo medical examinations before their employment could be confirmed. Those medical examinations took place at the home of the now deceased Dr. B. He was paid on a report by report basis by Barclays Bank. He had no retainer with them. He sexually assaulted the claimants when they attended his home, expecting to be examined for the purposes of obtaining employment with Barclays. Dr. B, and this is in the Supreme Court's view really the key feature, had a number of work streams. He was employed by local hospitals, and he also worked as an independent contractor doing work for insurance companies, a government board, and so on. And his work doing reports for Barclays was actually a small part of his overall work. Now, the High Court and the Court of Appeal below, adopting the broader Christian Brothers 5 factors approach, which I've drawn your attention to, held that vicarious liability was made out because it wasn't fatal to the claimant's assertion of such liability that Dr. Bates was an independent contractor, that he was in business on his own account. However, if we go to the next slide, please, Mel, the Supreme Court said that that absolutely was fatal, that was the determining feature. Dr. B was clearly in business on his own account. He had a portfolio of clients, including Barclays, and therefore really that was the end of story, that they couldn't be liable for the sexual assaults that he'd carried out on the claimants. And so by the contrast between the Court of Appeal and the Supreme Court's decision in that case, you see how the different approach to the legal principles plays out. If we can go to the next slide, please. We now then turn to the second element of the test. Again, Freddy will cover this in more detail, but just to flag some of the issues that might arise if you've got through to the second part of the test and you're considering whether there's a sufficiently close connection between the wrongdoing and the employment relationship, using the phrase employment relationship in its broadest terms for these purposes. Suppose, for example, the tort has been committed when the officer or employee is off duty. Suppose they are pursuing a vendetta of their own, or they're motivated by a personal bias or hostility. Are there specific rules or different approach that apply in sexual assault cases? To which the answer in the latter is yes. And in Morrison's, the Supreme Court recognised that. Freddy's going to talk more about that, but I emphasise that at this stage because it follows that what I'm about to say about the general principles does not apply in full in relation to sexual assault cases where the Supreme Court acknowledged different considerations applied. So if we could have the next slide, please. So we need to know what Morrison's decided. And this is what the Supreme Court said, that to satisfy the connection element of the test, the tortious conduct must be so closely connected with the acts that the tortfeasor was authorised to do by the defendant, that for the purposes of liability to third parties, it may fairly and properly be regarded as done by the tortfeasor while acting in the ordinary course of his employment. Well, that might sound like a rather traditional formulation of the test, and that's because it was a rather traditional formulation of the test. The Supreme Court, Lord Reed, gave the judgment, that was the collective judgment of the court, drew on a number of the sort of classic vicarious liability authorities, most of which date from more than 20 years ago, in order to emphasise that this was the test. And he also said somewhat sniffily that fairly and properly in this context did not relate to what the particular judge in the particular case thought might be a just outcome, but related to a looking back to the past case law and identifying the factors which pointed to the imposition of vicarious liability, and indeed those that pointed the other direction. Next slide, please. So how is that different to what went before? Well, said Lord Reed, Lord Toulson's judgment in the earlier case of Mohammed, and again Morrison's supermarket, had been misunderstood, and that in that case the Supreme Court had not intended to liberalise the previous law in relation to the connection test. You may remember this case at the time, it seemed as if it was quite a helpful case for expanding the connection test. The unfortunate claimant went to a petrol garage and asked if some documents he had on a memory stick could be copied there. The cashier employee told him to get lost in no uncertain terms and not come back, and then followed him out of the premises towards his car, parked on the forecourt, and then racially abused and assaulted him. In that case, the Supreme Court found that vicarious liability was established. Now, the Supreme Court didn't throw doubt on the actual outcome on the facts, but Lord Reed did explain the judgment in a particular way. So if we can go to the next slide, please. two things in particular of significance he stressed. Firstly, that Lord Toulson had not intended to say it was sufficient for there to be a temporal or causal connection between the employment and the tort. And the relevance of that was that in that case, you may remember that Lord Toulson talked about a unbroken sequence of events between the events in the kiosk and the cashier following the claimant out onto the forecourt and then assaulting him. Well said, Lord Reid. Yes, Lord Toulson used that phrase about an unbroken sequence of events, but he wasn't suggesting that was the test. He was simply using that in the course of discussion. And in fact, the key point in Morrisons was the finding that the cashier was still acting in his capacity as a cashier when he committed the tort. And secondly, of potentially wide importance, is that Lord Reid stressed Lord Toulson's judgment should not be read, as indeed it had been, as indicating that the tortfeasor's motive was irrelevant. It had been suggested that that was what Lord Toulson was saying because he did not regard the racism and racist abuse by the cashier, which was a personal motivation, as negating the vicarious liability. Said Lord Reid in this case, well, that's because he'd already was quite satisfied that the close connection test was met. But if someone was acting for personal reasons, said Lord Reid, it was highly material. And he restated the traditional distinction. I mean, I remember learning about at university, so Christ knows that was a very long time ago. But the traditional distinction between an employee misguidedly furthering his employer's business, where vicarious liability can result, and an employee pursuing a frolic of his own, as a rather quaint phrase has it, where vicarious liability would not apply. Now, next slide, please, Mel. As we can see, again, the distinction in the application of the facts in Morrisons. The employee in question was an internal auditor with Morrisons who became disgruntled with his employer. He copied personal data of thousands of employees and put it onto a website the public could access. He had first obtained that data in his auditor's role. He acted in that way because he wanted to harm Morrisons, his employer. And many employees brought claims in relation to the breach of confidence, breach of the Data Protection Act in relation to using the data in that way. And then if we can just go to my last slide, please, Mel, then we will see that the Supreme Court held that the connection element was not established. Yes, it could be said that there was an unbroken sequence of events in the sense that AS got the data in his work capacity and then caused it to appear on the a public forum on the website. But that was not in itself enough for liability. Nor did the fact that his employment gave him the opportunity to commit the wrongdoing amount to something that would impose liability in itself. The key point was that he was pursuing a personal vendetta aimed at harming his employer, and also that his actions could not be said to be something that, you know, was an unauthorized way of doing something he was employed to do. To the contrary, it went way beyond it. So, said the Supreme Court, applying the correct traditional approach, the courts below were wrong in finding vicarious liability in that case. And I'm now going to hand over to Freddy to talk about how the principles in these cases may play out in the policing and detention context.
Thanks, Heather. I want to begin by looking at the second stage of the test for the imposition of vicarious liability, namely whether the wrongful act was sufficiently closely connected to the employment or quasi-employment to justify the imposition of liability. It's undoubtedly the case that where there is no connection between the wrongdoing and the officer's position, then the chief constable wouldn't be vicariously liable. Mel, if I can ask you to go on to the next slide. In the case of Alan, the claim alleging a campaign of harassment by a police officer was struck out on the basis that there was no connection between the alleged harassment and the alleged perpetrator's role as an officer. Next slide, please. It's instructive to consider two cases concerning abuses of power by police officers, which were decided after Lister and Dubai Aluminium, and which were discussed by the Supreme Court in Morrisons. The first is a decision of the Judicial Committee of the Privy Council, Attorney General of the BVI against Hartwell. The case concerned a police officer who left his post and went into a bar where his partner worked as a waitress. In a fit of jealous rage at finding her there with another man, he fired a number of shots at one or both of them with a service revolver to which he had access in the course of his duties. A bystander was injured and claimed damages from the government. The connecting factors relied upon as satisfying the test were that, firstly, the officer on duty at the time was on duty at the time of the shooting. Secondly, the shooting occurred at a bar within his jurisdiction. And thirdly, he used a revolver that he was given and permitted to use by the police. Despite this, the Privy Council held that the government was not vicariously liable on the ground that at the relevant time, the officer had abandoned his post and embarked on a vendetta of his own. His wrongful use of the gun was therefore not something done in the course of his employment. It's worth noting in this case that in view of their knowledge of the officer's previous behaviour, the defendants were still held in breach of their personal duty. Next slide, please. Hartwell might be contrasted with the case of Bernard, also a decision of the Privy Council. Bernard had been using a public telephone when an off-duty officer announced police and demanded the phone. When Bernard refused, the officer shot him. The connecting factors were, firstly, the officer had asserted his authority as a police officer. Secondly, the officer fired the shot using the revolver that the employer had given him and which he was permitted to carry when off duty. And thirdly, the officer had subsequently arrested and charged Bernard with an offence, thereby asserting that at the time of the offence, he was acting in the execution of his duty as a police officer. Vicarious liability was held to be established in that case. Next slide, please. Now, the Privy Council reached the same view in Brown, where a private security company were held vicariously liable for an employee who pursued, shot and killed a man who had pushed him while trying to gain entry to the football ground. And that shows that the same approach can be applied to those purporting to act as private law enforcement. Next slide, please. Now, in Morrisons, the Supreme Court did not criticise the decisions reached in Hartwell or Bernard. And that implies, in my view, that both decisions were probably correct on their respective facts, notwithstanding the result in Morrisons. After all, Morrisons signals a return, as Heather said, to the classic formulation of the test in Dubai Aluminium, which is precisely what the Privy Council applied in Hartwell, Bernard, and for that matter, Brown as well. Brown and Bernard show that claimants can satisfy the close connection test, where an employee intentionally misuses a weapon provided by their employer. What Hartwell suggests is that mere access to the weapon might not be enough. There would have to be some additional connecting factor, such as an assertion of authority. Next slide, please. A few useful points arising in other cases in this area. Firstly, it's worth noting that acts of revenge or private retaliation are not necessarily inconsistent with the finding of vicarious liability. It's important to consider the circumstances in which the employee resorted to violence. So Mattis was a case about a calculated act of revenge by a nightclub bouncer for which the defendant nightclub was held vicariously liable. The court noted that the bouncer had been encouraged to act in an aggressive and intimidating manner towards customers. So insofar as employers and detention authorities have trained, instructed, encouraged, or permitted employees to act aggressively, that may weigh in favour of attaching liability to their employer. The courts have also recognised that an employer may be responsible for the acts of their employees even when they're off duty. In the case of Weir on the slide, an off-duty constable was assaulted by a claimant by throwing him down the stairs, locked him in a police van, which had been taken by the constable without authority, and then threatened the claimant with arrest or removal to the police station before letting him go. And the Court of Appeal held that the assault was committed in purported performance of his functions as a constable, albeit one behaving very badly. And similarly in Bellman, which was cited with approval by the Supreme Court in Morrisons, that was a case about an assault committed by a managing director at an office party, or an office after party. The Court of Appeal found that when he committed the assault, he was purporting to act as the managing director and asserting his authority. So although the context is different, Bellman shows that even where an assault occurs outside working hours and away from the working place, there can still be a, quote, very close connection between the authorized activities and the assault. Next slide, please. I thought it would be useful to consider whether the Ministry of Justice or whichever body is responsible for running the prison is liable where a prisoner assaults another prisoner. And reports suggest that prisoner violence have become more prevalent in recent years. So I think this is relevant. It's safe to assume that following the Supreme Court's decision in Cox, that prisoners are deemed to be employees of the prison while undertaking nominally paid prison work. So in the case of Cox, a prisoner had been paid to assist the prison catering manager in moving kitchen supplies. The prisoner had then ignored the manager's instructions and dropped the bag of rice, injuring her. The Supreme Court said that the working relationship between the prisoner and the prison could give rise to vicarious liability, even in the absence of a contract of employment, and even where the defendant did not derive a profit from the tortfeasor's activities. It was enough, in the court's view, that the prisoners were carrying on activities in furtherance of the defendant's interests. The decision of the Supreme Court in Barclays Bank did not comment on the employment status of prisoners. In my view, it doesn't disturb the ruling in Cox. Prisoners who are compelled to carry out prison work under the control of the prison are more akin to employees than independent contractors who may have the luxury of working for multiple people and with a greater degree of freedom to decide how they do their work. If the employment relationship is satisfied, the question will be whether the assault is sufficiently connected to the prisoner's employment or quasi-employment, and that will depend on the facts. And I've considered 3 hypothetical cases on the slide. Case 1, where a prisoner assaults a fellow prisoner while undertaking prison work. For example, a prisoner working as a chef uses a knife from the prison kitchen to stab a fellow prisoner during a shift. That might give rise to a vicarious liability. Case 2, similarly, if the prisoner used the same knife to assault a prisoner outside working hours, then there's an argument that the close connection test would be satisfied, but it may be more difficult. Case 3, if the prisoner obtained the knife by a different means, i.e. not through his work, it might be more difficult to show that the close connection test would be satisfied. Indeed, it may be difficult to show that the first limb of the test is satisfied as well. Next slide, please. Briefly, I want to talk about the Barclays Bank decision and its relevance to agency staff working in detention facilities, because that's something that's increasingly common. Whether they're considered, whether those staff are considered employees or quasi-employees will depend on the degree of their integration into the infrastructure of the detention facility, rather than their formal employment designation. And I've identified on the slide some of the key questions that you might ask yourself in these cases. In relation to the custodial healthcare example, which Heather mentioned, there are significant differences, in my opinion, between Barclays' engagement of Dr. Bates in the Barclays Bank case and healthcare providers' engagement of doctors in the detention context. Firstly, the decision of Barclays is banking, and Dr. Bates was providing an ancillary service. But the business of healthcare providers is healthcare, and doctors are providing a core service. Secondly, Dr. Bates provided a consulting room, equipment, etc., but doctors in prisons are provided with a consulting room, equipment, etc. In my opinion, these two differences may be sufficient to distinguish Barclays Bank and lead to a different result. Next slide, please. I want to look at the next issue of vicarious liability in sexual abuse cases, which Heather has pointed out are treated differently. Now, the most senior courts have held on several occasions that an employer may be vicariously liable for acts of sexual abuse committed by their employees. And the employer can be liable for acts of intentional wrongdoing, including where those are criminal offences. That remains good authority following Morrisons. And at paragraph 23, Lord Reid said that the close connection test is applied differently in cases concerning sexual abuse, which cannot be regarded as something done by the employee while acting in the ordinary course of their employment. So rather than focusing on the question of whether the wrongful act happened during the ordinary course of employment, the courts focus instead on criteria that are specific to the commission of sexual abuse, such as the employer's conferral of authority on the employee over the victims. And the rationale for holding the employer liable in these cases is that they have created the risk or potential for abuse by putting employees in positions of power or authority over vulnerable people. Next slide, please. The creation of risk itself is not enough to give rise to vicarious liability for abuse, but it is always likely to be an important element in the facts that give rise to such liability. In the policing and detention context, it would be important to look at the following factors in assessing whether the authority should be vicariously liable. Firstly, the opportunity that the officer was given to abuse their power. Now, in the case featured on the slide, the officer had met survivors of domestic violence and suffered, and those suffering from mental health issues through his work. He'd then returned to their homes while on duty to have sex with them on multiple occasions. It's arguable in that type of a case that the work gives him access and opportunity to his victims. Secondly, it's relevant to think about the extent to which the officer's wrongful act may have furthered the employer's aims and hence be more likely to have been committed by the employee. One instance of where that might be relevant is where sexual deception has been used in undercover policing. For example, officers working in the National Public Order Intelligence Unit who infiltrated political movements from the late 1990s until 2011 and formed sexual relationships with the campaigners they were spying on. The units claimed that the formation of sexual relationships was prohibited, but the intelligence units would have benefited from the intelligence gathered by the officers who overstepped the line. Thirdly, it's important to think about the extent to which the wrongful act was related to intimacy inherent in the officer's activities. So, for example, where a sexual assault occurs in the context of a body search of a detaining. Fourthly, I've noted that it's worth thinking about the extent of the power conferred on the officer in relation to the victim, and finally, the vulnerability of potential victims to the wrongful exercise of the employer's power. Next slide, please. Finally, I just want to look at two examples. There are very few reported cases of detaining authorities being held liable for sexual abuse by their staff because defendants will generally seek to settle arguable claims before trial because they are wary of the reputational damage of claims being litigated in open court. One reported case is the case of N, where the chief constable was held not liable for the criminal wrongdoing of an off-duty officer. Now, the constable spotted the severely intoxicated claimant being carried out of a nightclub. He then identified himself as a police officer and offered to drive her to the nearest police station. Instead, he took her home and raped her, and the court found that the officer had engaged on a frolic of his own. The fact that he had claimed to be acting in the course of his duty was important but not determinative. Next slide, please. That can be contrasted with the recent decision of TPKN against the Ministry of Defence, in which the claimant alleged that she had been raped and sexually assaulted by a member of the armed forces while they were stationed on a base. The alleged events took place after a social event where the individuals were not on active duty. Master Thornett initially awarded summary judgment in favour of the Ministry of Defence. On appeal, the High Court overturned the decision, finding that it was arguable that the Ministry of Defence were vicariously liable for the assault. The question of whether vicarious liability should be imposed in TPKN will now be addressed and determined at trial. However, Justice Sweeney's decision does indicate that the expansive trend in this area of law since N, which was the expansive trend in this area of law since N, which was decided before a number of landmark child sex abuse cases, such as the Christian Brothers case and the case of MAGA. Those cases showed quite how far the courts will be prepared to stretch the close connection test to make a finding of vicarious liability in the appropriate case. And nothing in Morrisons, in my opinion, changes that. I'm going to hand over now to Fiona to continue talking about non-delegable duties.
Thank you very much, Freddy. Good afternoon, everyone. I think we can all agree that few issues give claimant litigators headaches quite so much as outsourcing. And those headaches may reach migraine proportions when a common law claim is allied with one under the Human Rights Act. Fixing a single, ideally public body with all strands of liability is like a large dose of paracetamol. Woodland seemed to give us the key to the medicine cabinet, but as we will see, it does not perhaps offer the straightforward access we had hoped as the case laws developed since the judgment. Could I have the next slide, please, Melvin? As we will see, the 5 characteristics of a non-delegable duty identified by Lord Sumption in Woodland have featured prominently in most of the judgments that have followed it. I propose, therefore, to start with a recap. So first of all, we look to the status of the claimant. Is the claimant in an especially vulnerable position or dependent on the protection of the defendant against the risk of injury? Obviously, Woodland was a child in school, and the Supreme Court also made references to patient, prisoners, residents in care homes. And then secondly, whether there was an antecedent relationship, effectively an assumption of responsibility characterized by an element of control. Then number 3, the absence of control on the claimant's part over the defendant's decision to delegate their positive responsibilities. Fourthly, and the criteria that has created the most debate in the authorities that followed Woodland, the issue is whether the defendant has delegated some aspect of his positive duty and the third party is exercising, for the purpose delegated, the defendant's custody or care of the claimant and the element of control that goes with it. And fifthly, whether the third party has been negligent, not in some collateral respect, but in the performance of the function assumed by the defendant and delegated to the third party. Melvin, if we could have the next slide, please. Lord Sumption crystallised all of that into a pithy nutshell at paragraph 26 of his judgment, in which he posited the question as to be whether the alleged negligence occurred in the course of the very functions which the detaining authority assumed an obligation to perform and delegated to its contractors. And it's worth bearing in mind when we consider in particular the issue of whether it is fair and just to impose a duty. The benefit that the imposition of a non-delegable duty in Woodland was intended to achieve was to place state school children in the same position as their private school counterparts, as private school children enjoy the protections of contractual arrangements. that is in essence what Baroness Hill was saying when she talked about addressing the mischief caused by outsourcing. Next slide, please, Melvin. So the first case that followed Woodland of interest to us is the case of GB and the Home Office. In that matter, the claimant was detained at Yarlswood, which was run by Serco on behalf of the Home Office, and the claimant was seen by a doctor employed by a local GP practice and prescribed an anti-malarial drug, as the defendant was proposing to send the claimant to Nigeria, and there are clear rules relating to the prescription of anti-malarials in those circumstances. The claimant subsequently exhibited psychosis, which she attributed to the prescription. And Mr. Justice Colson carefully went through the criteria set out by Lord Sumption in Woodford. First of all, perhaps unsurprisingly, although it was argued to the contrary by the defendant, he found that there was no material difference between a prisoner and a detainee in an immigration removal centre, as each is held against their will and cannot leave. Secondly, since the claimant was being detained on the orders of the defendant, she was in the actual custody of the defendant. There was a significant element of control, including statutory powers to monitor, to intervene, and to make rules and provide instructions regarding how Yarlswood was run. There was a positive duty on the Home Office to protect the claimant from harm, and it was in recognition of the defendant's positive duty that detailed detention centre rules and immigration directorate instructions were made to Serco. So the control of the claimant was found by reason of the defendant's control over Serco, and therefore the claimant. Thirdly, the claimant was obliged to accept the medical treatment she was given. There was no free choice. Her position was different to someone at liberty. And then fourthly, the provision of medical care was an integral part of the positive duty owed by the defendant to the claimant. And that was on two bases. First, the general basis that the rules and other requirements imposed by the defendant on Serco all stress the importance of the provision of proper medical care. And then specifically, the anti-malarial prescription arose directly from the defendant's detention and control of the claimant prior to removal, and was an integral part of the positive duty assumed towards the claimant, the performance of which was then delegated to Serco. And it was for those reasons that the negligence related to the core function. Next slide, please, Mel. There was a reasonably lengthy discussion of whether it was fair, just and reasonable to impose the duty at paragraphs 42 to 43 of the judgment. It was remarked upon, Mr. Justice Colson remarked upon the fact that it would be unfair if the claimant had no recourse against the defendant merely because the defendant had contracted out the running of the immigration removal centre, and he considered it undesirable to create an anomaly. Secondly, the outsourcing should be irrelevant in law. It should not have to be for the claimant to try and work out which private contractor or individual doctor might be liable for which failure, and then litigate based on that assessment. And that's a refreshing indication, judicial understanding of the difficulty faced by litigators in that type of circumstance. Then also it was commented upon that the claimant was detained by the defendant. She was in the defendant's control, and she was entitled therefore to look to the defendant for proper protection. The defendant it was who decided to detain the claimant, and consequently the defendant had clear responsibilities for her treatment as a detainee as a result. It would not be just, fair or reasonable to conclude that those responsibilities disappeared simply because of an outsourcing decision. So far, so good. Next slide, Mel, please. And then we come to Arms and Nottinghamshire County Council. That's already been mentioned. And at paragraph 36, Lord Reid remarked that it wouldn't routinely be necessary for the judge to determine what would be fair and just as a second stage of the analysis. That really was what the criteria were intended to assist with. The critical question was whether the function of providing the claimant with day-to-day care was one which the defendant was under a duty to perform, or duty to perform with care, or was one which they were merely bound to arrange to have performed subject to a duty to take care in making and supervising those arrangements. And all of this was considered by reference to duties under the Children Act. The defendant under the Children Act was required to discharge their duty to provide accommodation and maintenance, not to perform the function in the course of which the claimant was abused. The claimant was abused in the provision of daily care in the foster home. The defendant's obligation was rather to arrange for and then monitor the performance of the arrangements. And it was commented upon that the catalogue of regulations with respect to placement and supervision would not be necessary if the local authority were in any event responsible for all the wrongs that might befall the claimant. And it was felt that a duty to ensure that reasonable care is taken for the safety of children in care while they are in the care of foster carers would be too broad. And a couple of other points that came up of interest was that in Lord Reid's view, Lord Justice Burnett in the Court of Appeal had been wrong to conclude that if there is no vicarious liability for an assault upon a child in care, then the common law should not impose liability via a non-delegable duty. There's helpful clarity that there is some clear distance between non-delegable duties and vicarious liability. And secondly, that he had also been wrong to conclude that a non-delegable duty cannot be breached by a deliberate wrong. Again, that's helpful with our assault cases. Arms looks very carefully at the Children Act, and you can see the logic of following through a piece of legislation of that type that is so carefully structured. Next slide, please. And then we come to Razimus and the Ministry of Justice. The background facts concerned a claimant who was detained at various prisons and received negligent general practice and secondary medical care, leading to the amputation of his left leg. Here, Mrs. Justice Cockrell did not progress through the 5 criteria from Woodford, but took, I think, what would be fair to be described as a more broad brush type of approach. She felt that the distinguishing feature of the non-delegable duty cases is control over the claimant for the purposes of performing a function for which the defendant has a positive responsibility. She concluded that there must be a, quote, nexus between the control of the claimant by the target, that was the term she used for the third party, the person to whom the duties were delegated, and the purpose of that control placing and the care inherent in that relationship. And she gave the example of a patient who places himself over to the care of the hospital for the very purposes of healthcare. And I think here she is applying Lord Sumption's 4th criteria, but the precise terms of that are that the target, to use her phrase, is exercising the defendant's custody or care of the claimant and the element of control that goes with it for the purposes of the function delegated to the target. And of course, the function must be an integral part of the defendant's positive duty. Personally, I find that framing of that aspect of the considerations much clearer. She then went on to say that the claimant, as well as being in the defendant's care, needs to establish that she was, quote, receiving a service which is part of the institution's mainstream functions. And she there cites Lord Sumption in Woodland at 30. But in fact, that's an error in citation, because that statement actually comes from laws in Woodland in the Court of Appeal. And then she goes on, Mrs. Justice Cockrell goes on to say that to similar effect, is Baroness Hale's point in Woodland that the conundrum there resulted from, quote, outsourcing of essential aspects of public authorities' functions. And both by use of that term mainstream function as opposed to an integral function, and the blurring of Baroness Hale's remarks generally concerning when it would be fair, just and reasonable to impose a duty with the assumption criteria, seems to me to add confusion to the thinking there and makes it harder to follow the process through to her eventual conclusion that there was no non-delegable duty. She also remarks that the reason for the prisoner being in the hands of the prison is not for and does not even comprehend healthcare. And she placed significant emphasis on the fact that healthcare since about 2003 has not been part of the prison's, the prison institution's mainstream, she uses that phrase again, or essential function, because it had been outsourced. It had not been outsourced by the defendant, it had been transferred to the Department of Health. She concluded that the provision of healthcare forms no part of the statutory or common law duty. She considered that the legislative backdrop in GB, the Immigration Removal Centre case, was entirely different, and she contrasted the express provision in Rule 33 of the Detention Centre rules to provide a medical practitioner versus the Prison Rules 1999, Rule 20, which provides the governor must work in partnership with local healthcare providers to secure the provision to prisoners of access to the same quality and range of services as the general public receives from the NHS. And although the defendant admitted that prior to 2003, prisons would have owed a non-delegable duty to prisoners in respect of healthcare, there is nothing difficult or surprising in her view that this duty would change with such a major change in the legislative arrangements. Next slide, Melvin, please. Thank you. And then the fourth case that I'm going to address is Ramdeen and Agido, and the second defendant was a dental practice. Here, the claimant received allegedly negligent dental treatment from Dr. Agido. That treatment was provided in fulfillment of an obligation of the dental practice under contract with Doncaster Primary Care Trust. Here again, the judge went through the Woodland characteristics, applying them with care. And the first question, she found that the claimant was accepted as a patient by the second defendant. The contract imposed obligations on the second defendant, the contract from the Primary Care Trust. That was to ensure that practitioners contracting with it had updated their skills and knowledge. It was not a simple administrative referral service. Secondly, the existence of an antecedent relationship with the second defendant was not affected by the fact that Dr. Agido could decline the claimant as a patient. She remained in the care of the second defendant, notwithstanding their option under the contract to delegate to the first defendant. Thirdly, the second defendant did not have control over the first defendant's treatment decisions, but did have control over to whom the claimant would be referred, and that was sufficient. The claimant's general dental practitioner could not refer directly to the first defendant. Then fourthly, the function delegated to the Dr. Agido by the second defendant was an integral part of the second defendant's functions. Second defendant delegated the claimant's care to the first defendant, together with the element of care that went with it. And then fifthly, the allegations of negligence related to the treatment, which was clearly not a collateral matter, but the very function assumed by the second defendant. And incidentally, the Primary Care Trust was found to have complied with its duty to secure the provision of dental services through its contract with the second defendant. Thus, the primary care trust's duty to take reasonable care was discharged by entrusting the performance to an apparently competent independent contractor. The claimant was not the PCT's patient. And so I think that's actually very helpful when you're dealing with characters like the G4S facilities services who provide healthcare services in prisons and the like, because they then often delegate out to multiple independent contractors. But that does seem to be a helpful authority in fixing at least G4S healthcare provision with non-delegable duties in respect of the totality of the healthcare. Could we have the next slide, please, Mel? It's difficult to reconcile Rasmus and GB, in my view. Mrs. Justice Cotterill found that distinction quite straightforward, and she found it straightforward by reference to the differences between the detention rules and the prison rules. It's also the case that Rule 3 of the prison rules states that the purpose of the training and treatment of convicted prisoners shall be to encourage and assist them to lead a good and useful life. And clearly, the Superintendents of Prisons is vested in the Secretary of State, and the Secretary of State commits prisoners to prison, and they are deemed to be in the legal custody of the governor or director of a private prison. And it's hard to see how you can discharge those responsibilities to individuals rendered vulnerable by their incarceration and to promote them in leading good and useful lives without having regard to their healthcare needs. I think all of this is ultimately going to have to be considered on a case-by-case basis, because certainly some of the prison service instructions, notably PSI 64/2011, which deals with suicide prevention, repeatedly emphasises the multidisciplinary aspect of the responsibility to keep prisoners safe, and indeed to share information, to record it and act upon it within the prison. And perhaps most notably, to ensure that all contracts, service level agreements with third-party providers reflect the need for multidisciplinary working in relation to at-risk prisoners. And this must be included as a business requirement and key deliverable. I think that means that in these circumstances, you have to look at the contracts and you have to look at the nature of the need displayed by a particularly vulnerable prisoner. And I would hope that it would not come to pass that the courts would conclude that it's not an integral part of the functions of, for example, a director of a prison to ensure the protection of that individual from the risk of suicide and self-harm. And of course, we have authority with regard to that in, for example, Kirkham. Incidentally, with prison healthcare services now co-commissioned by NHS England and individual prisons, I think that's a recognition of the fact that the aspiration to achieve an NHS standard of healthcare within prisons has not been achieved, does create a rather different circumstance to that which was before the court in Rasmus, when the sole commissioners were in fact the private primary care trusts. Thank you very much indeed.
Thank you very much to Freddy and to Fiona for their really helpful presentations. We have a couple of questions which I'll turn to in a moment, but before I do, I want to take this opportunity to encourage you to fire any questions or comments our way that you would like to do so. Take advantage of us while we're here. The time can go on till 4:30, doesn't have to, of course. Anyone can leave whenever they like. But if you want to take advantage of us, then please do. In terms of the messages we've received so far, one is not so much a question, but it's a really useful point. So thank you to whoever passed this on. They did so anonymously. But they've made the point that in the last year or two, the police have introduced standing operating procedures in relation to FMEs, requiring FMEs to carry their own insurance and spelling out as far as they're concerned that the police forces will not be vicariously liable for the actions of FMEs. Now, obviously, whilst that's not conclusive, but one might well expect a court to take that as a fairly strong steer in a direction away from vicarious liability. So thank you very much for that. Secondly, we have had a question based on a particular case scenario from Andre. I hope he doesn't mind me mentioning by name. Andre, there were a couple of points that I wasn't entirely clear about. I've liaised with Freddy and we've agreed that although my name doesn't start with F, I'm going to have a bash at answering this. But while I'm answering it, or immediately afterwards, if I've misunderstood the facts, then please do tell me. But we can have a discussion around my understanding of the facts in any event, but do get back in touch if I've misunderstood. So broadly, as I understand it, the situation is this, that a revenue inspector made a false complaint against Andre's client, which led to their arrest and subsequent prosecution. They were acquitted at trial, and the revenue inspector was quite actively involved in the whole thing, because at an earlier stage the police were going to, it was the British Transport Police, were going to drop the case after they viewed CCTV, but following the revenue inspector exercising the victim redress scheme, they decided to charge the claimant and crack on with prosecuting. So we are asked about vicarious liability. What, unless I've missed it, the question doesn't say, is the tort or action in question. I'm assuming it's malicious prosecution. So I'll assume that for the purposes of answering this question. But if I've got that wrong, as I say, do come back to me. If you're suing in malicious prosecution, you're presumably suing on the basis that the actions of the revenue inspector in making the false complaint was in effect, rendered him in effect, in substance, the prosecutor, and therefore liable under the tort of malicious prosecution. You may also, I suppose, be suing in misfeasance if you're claiming he was exercising public functions at the time. But what I'm not quite clear from the question is whether the revenue inspector was on duty or off duty at the time of the events that he made the false allegation to the police about. With those qualifications, looking at it both ways, I understand that the revenue inspector's employers have denied vicarious liability. As regards their position, well, obviously the first limb of the test is satisfied. There's an employment relationship. Is there a sufficient connection with between the tort, making the false complaint that led to the prosecution, and that employment? That would depend, in my view, on, as I say, the capacity in which the revenue inspector was acting when he made the complaint. And I don't have that information currently, but by all means, come back on that, Andre. Secondly, if you are thinking of trying to make the British Transport Police vicariously liable, then in a conventional legal sense, they are not the employer, as I understand it, of the revenue inspector. And so it's the first limb of the test where you would have quite a high hurdle to overcome, because on the face of it and subject to knowing more detailed facts, it wouldn't appear that the revenue inspector was acting as, for example, an integral part of the British Transport Police's business when he made the complaint that he did. I mean, that's not to say that you haven't got a good argument there, but I'd need to know more facts to know if that was a realistic argument. So that's my answer at this stage, but I see that some more messages have been coming in while I've been talking. So I hope people will just give me a moment to check. So yes, so I understand cause of action for malicious prosecution and harassment. that he was on duty at the time when he made the complaint and made the statement. And the suit is being brought against the employers of the revenue inspector. Okay, thank you. That's very helpful, that additional clarification. So, yeah, no problem then with the first limb of the test. And as I say, with the second, it will be a question of drilling down into as much detail as possible to show that the revenue inspector was exercising functions related to his employment at the time. But you're off to a good start with the fact that he was on duty. You may face, in terms of anticipating the sort of arguments that you could face, arguments that he was pursuing a personal animus or some kind of personal motivation in making the false complaint. I'm not clear of the background as to what triggered the actions that he did. But I think if that is the situation, for the reason that we've mentioned before, and particularly Freddy discussed, it's certainly, post these recent authorities, not enough for defendant to simply say, well, so-and-so had a personal reason they weren't fulfilling their employer's purposes at the time. It's more subtle than that, provided that you can identify a link to the individual's duties. I hope I've covered the points raised there. By all means, come back to me if I haven't. In the meantime, because I just want to look at that slightly more detail in case I've missed any of the additional information supplied. Can I throw out a question? So I'm going to throw out a question to Fiona. Does it make any difference if the cause of action is one under the Human Rights Act? Because you touched on that at the beginning. Suppose, for example, it's a situation where it's being said that harm or death even was caused by a breach of the operational duty under Article 2, Article 3. Would that have any impact? Would there be any difference in that sort of situation as compared to the common law approach to non-delegable duties?
The reason why I mentioned the potential complexities that arise where you've got a common law claim and a Human Rights Act claim is that you may have a good, clear and obvious defendant who is not a suitable Human Rights Act defendant because they're not a public authority. So you're having to try and cobble together who you're suing, and you would ideally like to fix the public defendant with a non-delegable duty. I think so far as the Human Rights Act is concerned, it operates differently because you're not in the realm of non-delegable duties. You are potentially in the realm of having a claim against the state, an entity that's not recognised in our jurisdiction. And I guess ultimately, if your Human Rights Act claim were to fall because you cannot sufficiently fix liability on one or more emanations of the state, your remedy would be in Strasbourg. That would be a very extreme circumstance. But I think that the principles that underpin considerations of non-delegable duty would have a relevance in the same way as we apply Limitation Act principles to considerations of extensions of time under the HRA, but I don't think they're in any way directly applicable. I think possibly the public policy considerations maybe come into play more fully, although the criteria are only supposed to be an expression of why it's fair, just and reasonable. And we may end up having those criteria unpicked by the Supreme Court as they did with their own criteria, what we thought they were on vicarious liability side of things. I would just mention in relation to that question, the point of information about the FMEs, I think that there's a strong argument in favour of a non-delegable duty where you're addressing issues of safer custody as between the chief officer and FMEs employed or contracted by the chief constable. So they may think they're wriggling their way out of vicarious liability, and they might be right, but I don't think they're wriggling their way out of the non-delegable duties through that in the same way. That may become more important.
Thank you. That was very helpful. I've got a question now for Freddy. if he'd like to have a go at answering this one. I think hopefully, Freddie, you can see the question on the screen as well, but I'll explain the question anyway for the benefit of our attendees. One of our attendees has asked, can vicarious liability be established in the following scenario? An intermediate treatment program for children where the individual running it is not employed by the council, but the program is extensively, albeit not wholly, funded by the council and also endorsed by a child social worker. The social worker encourages the child and the child's parents that the child should attend the program while living at home on trial. The child is on a full care order to the council, but is on trial at home with parents. The child goes on to live with the individual who runs the program for lengthy periods during which they are sexually abused. The child's parents are as vulnerable as the child. I hope that's clear. Would you like to have a bash at answering that one, Freddie?
I'll try. The difficulty, firstly, would be satisfying the first limb of the test. It seems as though the individual in question isn't employed by the council. So the question would be whether there's a relationship that's akin to employment. I haven't thought about this in much detail, but it seems as though the connection that's being suggested there is in terms of the funding arrangement. Do you have anything? I mean, Heather, do you have any thoughts on where that goes? I'm aware that the case of arms may, which also, as well as dealing with vicarious non-delegable duties that Fiona spoke about, also touches on the first limb of the vicarious liability test. In relation to a similar type of or into sexual abuse cases in the foster care system. But I'd need to think more about how that applies in this case.
Yeah, I think we need to be looking specifically about how much we could show that this individual who conducted abuse was kind of integrated into the way that the council ran its services. And obviously you've given some information there, but I think particularly post Barclays Bank, that's going to be at the heart of it. And also, what else did this individual do? I asked that because in terms of the aspect of whether he's in business in his own account and doing running this program linked to the council is maybe just one of a number of things that he does. Or whether that's front and centre of his activities, and as I say, very closely integrated into the way the council run things. I mean, that's just an example of the kind of distinctions which might be relevant on the particular facts.
Yeah, I think that's sensible, and obviously in the arms case, that in terms of the integration point, the question was about the extent to which the local authority was involved with the recruitment, selection and the training of foster parents, and the expenses that were paid for the fostering. But yeah, I think you're right that there's a limit to how far we can talk with this hypothetical or this case without knowing a little bit more about the nature of that relationship.
Yeah. But we can say that's the sort of crux to home in on. Another question, I'm going to throw this open to all of you, as this is also a very interesting question, if I may say so. This one's come via the chat, if you want to have a look at it, fellow panellists. Says the Supreme Court has obviously sought to contain vicarious liability, but how will the COVID-19 crisis affect claimants' prospects in the short to medium time? For instance, claims against defendants that are public bodies but were strapped for resources. Are the courts likely to be more sympathetic to claimants in borderline cases? I mean, if you like, I'll step in first of all. I mean, the thrust of both the cases, which were decided in effect by the same Supreme Court, Lady Hale giving the judgment in one and Lord Reed giving the judgment in the other. Lord Reed could hardly give the judgment in the Barclays Bank case because implicitly he got it wrong in terms of applying the 5 factors. I forget if it was Cox or Arms now, but one of them he gave the judgment. But I think the thrust of both those cases was very much, you look at the traditional tests, you look at the factors which the courts have held up to now, either constitutes a relationship akin to employment or the sufficient close connection. You, the judge, you shouldn't embark on this kind of touchy-feely, does it feel just in the circumstances to impose vicarious liability or not impose it? And the reason I raise that is because I think underlying your question is the sense, which one can understand, that there might be more sympathy for public authorities battling on many fronts in and following the COVID-19 pandemic. But on this sort of more traditional purist approach, if you like, that the Supreme Court's taking, that shouldn't really be relevant. I mean, of course, we all know judges are humans, or allegedly so, and, that may be an underlying factor that plays on their mind. But the mark, the seal, if you like, that the Supreme Court has attempted to imprint in these recent decisions is you, the individual judge in an individual case, don't get too hung up on policy, justice, who has the means, etc. You must look at the traditional tests and how they've been applied in the past case law. I don't know if either Fiona or Freddy want to come in on that point.
Yes, I do agree with that, Heather, and I think possibly another aspect of the circumstance that we're going to be in post-COVID is perhaps more pertinent. I mean, it's always an issue where you have to be tactical about who you choose to be your defendants. And I think everything that I've heard from you guys this afternoon and that came to my mind when I was preparing the slides is the importance of pre-action disclosure and getting all of this absolutely clear, both in the pre-action correspondence and the documents underpinning it, because exploring the nature of these quasi-employment type arrangements is now going to be absolutely critical. And of course, if you are bounced into making those decisions late in the litigation, it can lead to very costly mistakes. So I think it is a matter of trying to get ahead of it, setting it all out in correspondence, and so that you can then focus in on a defendant whom you know to be good for the total claim that you're making, and have the money, ideally, or essentially rather, to pay any damages that are awarded against him or her. I think that's going to be more important with limits on public funding, judicial patience. I think all judges have been quite grumpy in my experience in lockdown. And I think we're going to need to keep ourselves focused and litigate with a degree of precision in the new climate. But that's possibly always true.
Was there anything you wanted to add, Freddy?
No, I think that covers it.
Okay, well, that's great. Last chance if anybody has any more questions. As far as I can see, scrolling through, we've covered now all the questions that have been asked. Assuming no further question pops up in the next minute, it just remains for me to let you know that the slides from today's talks will be available, to draw your attention to the fact that there will be another webinar from members of the Actions Against the Police team towards the end of the month. I think we don't have an exact date yet, but towards the end of July on Equality Act issues. So look out for that one. You'll be contacted about that in due course. And lastly, I would just like to thank my fellow speakers for their really useful presentations today and very helpful slides. And thank you all for joining us. And we hope to see you again shortly. Take care for now. Goodbye.
Bye, everyone.